Thailand since I saw you last. Oh, yeah? 2 weeks before. It's 95% Buddhist. Right. The Buddhist temples all over the place. When the young Buddhist guys come out, you know, they're major shade or very small guys around their body. Come out with these steel bowls.
Enio?
Looking for food donations. People bring gifts of food every day. And there's other venues out there.
That's how they sustain it.
They don't have to work for their food. There's other venues that are selling food.
40 seconds, okay.
You build up a great bend over and bow to the Buddhist and pray.
Hey, Alan, you want to come up and talk about this briefly?
I wonder if there is this. Ready, Gary?
Yeah.
That's what is there, believe me, I never tell. Except for the six stages of heaven.
Okay, this is another meeting of the Houston Property Rights Association. We're going out intergalactically, as you know. This is our 22nd year of operation. We do this roughly 42 times a year. And we bring in speakers usually on local issues, sometimes Texas issues, sometimes national issues. We're being broadcast by the Houston Media Source, and this will be archived on YouTube. And so if you want to hear it again, you can just check out YouTube in 4 or 5 days and you'll find it there. And I'm Barry Klein. I'm the president of the Houston Property Rights Association. And today we're going to have a presentation on life in the criminal courthouse down here in Harris County, Texas, where Houston is located. But before we get to our main presenter, we talk a bit about other matters. And one of the hot issues in Texas today is what's called Proposition 1. This is a proposed amendment to the Texas Constitution that will put in the hands of TxDOT and effectively the highway lobby $1.7 billion out of our rainy day fund. That's an annual estimate, and that's what the first year's estimate will be. It may be less next year because it looks like we may have passed the peak in our recent petroleum and fracking boom. We see how that works out. And the Houston Property Rights Association is opposing this measure. We're arguing that, in fact, there is no crisis in Texas transportation, that TxDOT and other people who are in the business of talking about highway traffic have a self-serving methodology that exaggerates the need for new facilities. They typically rely on a computer model that is projecting two-hour commute times 20 years out, without acknowledging to the public that when the travel time becomes intolerable, people adjust where they live or where they work, so that we have these spontaneous forces at play that keep the travel time under half an hour in all Texas cities. And overall, Texas average travel time for the work commute is probably around 25 minutes. It's 28 minutes in Houston area. Yes, Jimmy?
Barry, don't you think with our growing population in Houston and more cars and more people, that drive time has got to get higher than 30 minutes?
Well, I'm glad you bring it up. As I say on radio, that's a good question. And the reality is that as the population grows, they bring in more and more cars, people are making adjustments. As they find their travel times are intolerable, they change how they live and work in the city, and so the travel time stays under half an hour. Now this happens, and one of the results of this phenomenon is that downtown Houston has only 5% of the area jobs. The jobs have moved out to the suburbs where people live. Only 5%. And so you live in one suburb and you work in another suburb. That's the common pattern today. And of course we have different ways we can arrange our work times. At work, some go in at 7, some go in at 9. So we spread out how we actually work. So all these things are not being documented by the highway planners. They give us a very simple presentation of future traffic needs by using a computer model, but that model lacks a feedback loop which reflects all these factors at play which keep the travel time under half an hour. So what we're doing is trying to promote this understanding statewide, and after we have our election on November 4th, the issue will not go away because TxDOT says this is 1.7 billion is only 1/3 of what we need. We need more like 5 billion, maybe even 7 billion a year in new money. And so they're going to go to the legislature and ask for more money. So I'm doing what I can to spread this understanding. I hope I can find some people willing to present an alternative point of perspective on traffic and take that to the legislature and get them to understand that the text audits give them a very self-serving kind of explanation of the dynamics of traffic. Jimmy again.
Justin was just telling me that the city council voted unanimously to get this new high-rise building going on downtown. It's a residential building, $15,000 tax credit over 10 years. Have you heard about that? For apartment.
Oh, that's a common thing with downtown development. A very common thing. What I found interesting in yesterday's paper is that maybe it's the same high-rise we're talking about, and they're building to a market which is in fact partially stimulated by congestion. There's the fellow, the executive from that firm, said that people don't like to travel more than 20 minutes to get to work. We're building to serve that appetite. So that, I think, underscores my point, that the development community will serve that appetite, that desire to keep the travel time under half an hour. So, Steve.
The adjustment process you mentioned may be part of the expansion of the suburbs.
Oh, you're right, absolutely. Right, and so we have at this point 15,000 miles of road in Harris County, and most of the jobs and most of the homes are out there far beyond the downtown, and that's where people are living and working. There was a time, perhaps 20 years ago, maybe even more recently, that the local arm of TxDOT would put out a map showing how long it would take to get from an outer part of the region to a downtown job, underscoring the misrepresentation of the nature of traffic and commuting in the Houston area. I don't know if they still put that out, but that was something I would commonly pick up back in the 80s and 90s. Yes, sir.
I'd just like to make a point that from your email that what was really the final blow to me is the idea that they're just really asking for a blank check. I mean, it might be a different thing if even what we're hearing here, that if they were to put out and say, well, we want to do a $5 billion of bonds to build this and this and this, but they're not doing that. They're just asking us to trust them. And personally, I don't trust them. So I think that they need to make a proposal and then let me evaluate that and have some public discussion about it.
Good point.
Well, that's a very good point. And now we rarely get an opportunity. I don't think it's ever happened in Texas that we can actually get to vote on a particular highway project. It has happened in 1 or 2 other states on individual projects, but it's sort of planning by ballot box. It's criticized by planners, and I can see that. I can see the logic of that criticism, and yet I can see why it's still appropriate, because we do get misled into giving them a blank check. Something like we just gave HISD. You know, they made a number of promises a year or 2 ago. They got approval for $1.9 billion worth of new schools. And of course, now we see that the promises they made then are not holding to. They're actually changing the project and upsetting some of the neighborhoods.
Barry.
Yes.
One more thing. You talk about that $1.9 billion going to the school district. Several years back, our country, when we were involved with Iraq, we spent over there $20 billion in cash in $100 blocks of money.
I recall. And it went out there on pallets wrapped in plastic.
Yeah.
Right.
11.7 of that money is unaccounted for.
Oh, I know that.
What idiot would approve that kind of nonsense? Send over that kind of cash. That's crazy.
I fully agree.
Our own people would take it home.
I know it's government is hard to keep accountable and hard to monitor. I think that's a good argument to keep it with fewer responsibilities, and have less to do and less to oversee. So okay, so oh yes, I have a comment over here. Justin.
Mary, what's the cost of all these adjustments in travel time as compared to using current infrastructure more efficiently?
Well, I think that's what I'm talking about, is that the existing...
Well, you put some numbers on it.
I Can't put any numbers?
Oh, okay.
Okay. I'm simply pointing at a historical pattern. We've had growth.
It's a good rhetorical point.
I'm looking at past numbers. I don't have any current numbers, but I'm saying the past numbers would give one reassurance that we're not facing gridlock if we don't approve all this new money for TxDOT. I drove over here today at noon, right? I'm going over the speed limit. I confess, I went over the speed limit to get here at the third busiest peak in the day. And so that's a sign to me that we have more road capacity than we need. If we can actually speed during a peak period.
Did you drive on a TxDOT road?
I did, yeah, yeah.
No, we won't tell them.
Well,
That's already out for the record.
I've got a good defense attorney here at my side. I'm not worried.
Did you run any red
Most of
lights?
the roads, are local roads.
Barry, did you run any red lights?
Two or three, but there's no cameras up there. What do I have to worry about? I always look. I don't want to hit anybody, but they have more cameras than they need. I mean, but you have more stoplights than they need.
The intersections without cameras are having more accidents.
You know, there's a city in Europe that actually has removed all the stop signs and I think all the stop lights and just letting people spontaneously adjust to traffic.
Let's put it this way, it sounds like that means that I will pay attention at the corner to make sure.
Absolutely, right. People don't want to be needlessly involved in accidents. So let me move on to my second hand. Now, I haven't actually talked about my first handout. So this is a new handout from Freakonomics, the articles from Freakonomics, and he's talking about some of the people I've been reading about over the years that talk about this pattern of keeping of your travel, the daily travel budget of perhaps an hour or longer, maybe even up to 90 minutes a day, though apparently it's looking over the big picture, it's like 1.1 hours a day. People like to travel, they don't like to travel too much on average. And so by looking at this, I think you can see that the average travel time for a commuter is under half an hour, and that's within a daily travel budget of perhaps 1.1 hours a day. And he looks at some of the well-known scholars who have talked about this phenomenon, including Cesare Marchetti. Do we have anybody here who took Italian in college? Am I pronouncing that correctly? Is it Cesare Marchetti? This fellow is a well-known physicist now in his 80s. And some time ago, he got a hold of the work of Jacob Zahavi. We have a hand raised.
Well, I was told by an Italian person that it's Cesare. If you're in Italy, it's not Caesar, it's Cesare.
Cesare. I thought I might be wrong on that. Cesare Marchetti. And so he got a hold of the work of Jacob Zahavi, who's the Israeli researcher that ended up working for the World Bank, and even for a time in Houston at the Houston Galveston Area Council back in the early 70s. And he came up with the idea of a travel time budget and also a money budget of perhaps up to 15% of annual income, maybe an hour a day in daily travel. And so Cesare Marchetti looked into that even further, and he determined that if you go back and look at what the archaeologists have turned out, that the villages, even in prehistoric times, were about an hour's walking distance apart, which meant that you probably worked fields no more than a half an hour's walking trip from your village. And so that means the average commute in the time of Christ in Palestine was under half an hour. So all this helps support the idea that people have a time budget and a money budget that becomes a controlling factor in their daily lives. Now this is part one of a two-part report that this man has written, and he has a part two, which I'll bring you next week, which is a little bit less firm than I'm actually saying it, so we can discuss that at that point. But I think the argument is still pretty sound overall. Now, the other item I have before you deals with the cost to the Houston area taxpayers who pay the 1% sales tax into the Metro account. Metro, of course, is our transit authority here. And by my estimate several years ago, it's $500 a year on an average family, Houston area family. I don't think most people realize that. They think of it as a penny, it's meaningless, a penny on the dollar, but it adds up. And with that money, Metro is overfunded, and that's why they're spending money building multi-billion-dollar rail systems that are only replacing existing and much cheaper bus service. But it all grows out of that hysteria that we've been fed about growing traffic. Back when we had the election to create Metro in 1978, the Political Action Committee promoting the decision to approve the new transit authority with the 1% sales tax had a flyer which says that the growth in traffic is so severe coming in from Katy to downtown that in 10 years, meaning 1988, it would take us 12 hours to make that work trip. So that's how they extrapolate a trend and get the public stampeded into making excessively generous decisions that actually goes, for the most part, in the hands of the people who actually work for the agencies or the contractors. Excuse me while I take a sip of water. A hand over here, Justin.
Did you add the federal contribution in there? That's just local.
Oh, I think I threw in an assumption at the end for 5 or 10%, but it's local. It's primarily local. I think I did it in the case of there's some management districts that actually go to the feds for grant money and they throw that into the Metro project. That's what happened in Midtown. Neil.
A number of years back, I blogged that a high-level city Houston bureaucrat who actually left the city shortly afterwards made a prediction that by the year 2030 that Houstonians would have a 3-hour commute.
Yeah, that was Mr. Chong or Mr. Chang. I recall reading that.
Mr.
And when I first read that, because we're used to thinking of the one-way commute, but that was his cumulative trip in, trip out commute. So actually, it was more like a 90-minute one-way.
It's still horse high.
Ridiculous, right? And I wonder why he was dismissed so quickly after you revealed that. Was it just going to be coincidental? Or were his bosses upset that he put out such a number that would be so unbelievable to the ordinary Houstonian? Okay, so we've been stampeded into putting too much money into transportation when we have solutions that are always at play. Individuals, when they find themselves facing unwelcome travel times, they make adjustments to their lives. They can move closer to the job moves closer to them. Merchants are building new shops closer to where the unserved enclaves and residents are. And what's the third thing? I think that's probably it. Merchants, workers, and employers are all changing how they use the road system based on congestion and how irritating it may be. Okay, let's bring up.
Tony has a question.
Oh, a question. Okay.
I just wanted to point out that as many as since 1978, we've had what, a 60% increase in population. There are a lot of well-educated adults, I'm just getting the idea here talking to Lynn today, that come here from out somewhere else, which is most of the people now, and they probably really don't know that we're paying 1% for that sales tax. And so that needs to be brought up too, because that 1% of, it is 1%, isn't it?
Right.
They divided some of it into highway, but it's still unclear.
It's about $500 million a year, and about 25% is shared with the 16 overlapping jurisdictions for road work. By the way, that wasn't being done back in the early 80s when I began to fight Metro's heavy rail plan. I brought it up. I went back to the 1978 plan, found that commitment, and began to talk about it. And so after that election, the mayor at the time and the county judge then pounced on Metro, which at that point had saved about $300 million for rail. And they began to draw down that saved up money for road work. Steve.
Relevant to the laying down of pavement, just wanted to point out that historically, paved roads of any sort, from the Romans and before, have put their pavement down on established trails. The trails, the pathways were there before. They simply expanded them and paved them.
I think that's partially true, but I recall reading the early roads in Harris County. They would build those where the property owners' boundaries would meet, and they would use actually slaves at the time to periodically put in like 2 or 4 weeks a year on road work and maintenance. So yes, early trails are part of that, but also they found ways to use the existing property boundaries.
Well, also, some years ago, the campus at Tulane University in New Orleans was going through some building or renovation, and people were puzzled that as part of that, they did not put down sidewalks. After a couple of years, the students had made the paths along their most efficient routing, and that's where they put the sidewalks. The students used the sidewalks, and there were very few other paths that they took to wear out the grass.
Okay, that's a good idea. Yeah. Okay, I should also, let's see what I also, had a call yesterday from a fellow up in Arlington. He's running for the House as a Libertarian, but he's also very angry about red light cameras. And he's organizing the Tea Parties and Libertarians to get rid of red light cameras in Arlington. That's a fairly large city. He's got 5 early voting sites he's got covered. He's working with a woman who's very active in the Tea Party. They already have, I think, 6,000, or they expect to have that in a day or two, and they only need about 9,000 valid signatures. And on election day, they've got 10 voting sites covered with people with tables and booths and clipboards. So they expect to do very, very well, I guess assuming it doesn't rain, in Arlington to get enough by election day to put that issue on the May ballot. So that's quite exciting. And another petition drive taking place, now of course that's to ban red light cameras. There's another similar petition drive taking place in Willis in North Harris County, close to Houston. That's a small city of 6,000. The activists actually went out there with their own table and booth and got over 100 signatures on early voting, first day early voting, but found out only one was valid. All the rest were not living in Willis. So she's changed her tactic, and now she's just going to focus on election day. And if she falls short, of course, there's always block walking. So we have 2 ongoing petition drives this election go around, and I expect we'll have even more come May of next year, or come the springtime. Let me bring up Alan Vogel now. Alan Vogel is the land-based representative of this guy who's flying over the countryside, the super dude. And Alan, why don't you tell us about this project?
Thank you, Barry. I'm with the Medical and Personal Freedom Political Action Committee, and we've devised a way to put a marijuana referendum on the ballot next Tuesday. As you know, there are changes going on all over the country in marijuana law, particularly in 3 states, California, Colorado, and Washington. And all of those changes have been the result of citizen initiatives. But we don't have initiative and referendum in Texas, unfortunately. So we decided to run our own initiative, our referendum. What we're doing is we've selected a statewide candidate. You see him here flying over the countryside. His name is Jamie Balasia. He's a candidate for Attorney General. He's a former police officer in Austin. He's now a criminal defense attorney in Austin. He's a member and board member of NORML, the National Organization for the Reform of Marijuana Law. We have selected him because he's got a good basis in this issue on both sides of the issue, both as a police officer and as a criminal defense attorney. We think that this is an issue that is coming late to Texas, but we can accelerate the motion in Texas by conducting this referendum, or we're calling it Referendum 2014. We ask you to vote for Jamie Balasia for Attorney General next Tuesday as a signal to the legislature that we need some changes in Texas. The changes are coming. We're spending over $400 million a year in Texas on marijuana prohibition right now. The changes are coming. The Marijuana Policy Project has bills that will be introduced into the legislature to talk about medicinal marijuana, to talk about changing how we treat people who are arrested for marijuana instead of putting them in jail and wasting all of that money using something along the lines of a civil fine, and ultimately changes in marijuana to make it totally legal in Texas. They are planning a 5-year program in which by 2019 they believe they will have succeeded. This is our effort to bring that along. Please go vote for Jamie Balasia next Tuesday and help that effort. Thank you. Walter?
Hey, you know, that may be a very close race with Sam Houston, the Democratic nominee. How are you going to, don't you think you might be taking votes away from one or the other?
Good.
Well, which one do you like the best? Or
I like Jamie Balasia the best.
Yeah, but what about Sam Houston?
I like the old Sam Houston.
Sam Houston's running for attorney general.
He's a Democrat too.
Well, you don't know nothing.
He's a commie.
He actually won the bar poll for more qualified than the other three. When they did it with 4 candidates, Sam Houston led the bar poll and qualified and well qualified. He's what party? The Communist Party, the Democratic Party. Yeah. Cool.
Well, there's not that much difference, yes.
Yeah, I think he may lead the Democratic ticket. He might actually win.
You think he's a reincarnation of the other Sam Houston?
Thank you, Mary.
Thank you. Now, I should mention that it wasn't really planned to get an advert for the Libertarian candidate. So if we have any Republicans here who want to speak for the Republican candidate, I guess Walter wants to talk for the Democratic nominee. Do we have anybody else who wants to speak for the other parties' candidates for that position?
I may vote for this.
I guess not. I guess there's nobody here who likes the Democrat or Republican that much. Or the Communist Party or the Socialist Party? Okay.
Yeah.
I like Wendy Davis for governor.
Okay. Somewhat off topic, but I understand. Okay. We have no other thoughts or compelling information. Pass. Pardon me?
Did you talk about the meeting yet, that you went last night to?
Oh, the high-speed rail.
Yeah.
Yes, I did not talk about that. In fact, I got some handouts which I forgot to bring with me. But the high-speed rail project is now being launched. They're holding scoping sessions. A federal agency has officially embraced the project, which I mean, in my mind, it means it qualifies for federal money. And so it makes me suspicious that it will be simply privately funded. And they had a big meeting up in Huntsville. I understand there was a lot of unhappy people who came to that meeting. And that and there was a lot of unhappy people at the meeting I attended down at the old Astrodome site. What was that name of that stadium now? NRG?
NRG,
Yeah, NRG, okay. So that's where it was held a couple nights ago. And of course, the former county judge, Robert Eccles, is leading this effort. I spoke against it, pointing out that I had worked with the opposition 20 years ago. I can't recall how long ago it was. To fight the earlier plan, which I think they called the Texas Triangle Plan. But the arguments are still the same. And now we have a fresh one, which is the California debacle. It was like a $9 billion voter-approved project 4 or 5 years ago for like $40 billion total. And now I think it's closer to $100 billion current estimates. It's really gotten out of hand. I think they're desperate to find some way to back away. But they still like the idea of creating jobs with the construction project, so it hasn't actually been dropped yet.
Well, in Huntsville, the main opposition came from Grimes County. People just flocked the thing, objecting to this. You're going to take my cow away. You're going to run over my cow. You're going to run right through my pond and all. There were only 2 of us that really spoke in favor of this, and I talked to you about that. But I definitely think it's a damn good idea, and I wondered, I put it out that you're going to let a little 2-bit county, of course I said that in good humor, stifle progress? I mean, Grimes County people are going to keep this thing from...
Here in Texas, trying to end the 19th century, and those guys with the cows are trying to stop us. You know, how can they be so selfish?
Are they going to use existing right of way? Or new, they're going to have to...
They're going to claim that. Yes, they're going to claim that until they don't claim it any longer. Yeah. So there was actually opposition from Houston's first ward, because apparently one of the possible alignments will take and use some existing right-of-way through the first ward, and they don't like that.
Well, they don't have, nobody has to sell their property. This is a private enterprise deal.
Oh, they're going to be a railroad company under Texas law. They got eminent domain powers, and
It's like a pipeline.
yeah.
Yeah.
No, they will have eminent domain powers. Wayne,
No, it is, Jimmy. It will be eminent.
Wayne, quickly, we have to move on.
To change the subject for a second, it's only about once on the average every 7 years that we actually have a meeting on Halloween, and I thought everybody would forget about it, except I didn't, so I did bring a pumpkin here, the jack-o'-lantern, and for those of you who have Alzheimer's like me, who I suspect quite a number here you might check out the 6 musical symbols that are on there and see if you can figure out what they are. So.
Oh, okay.
Bravo!
Bravo, good, right.
Very,
Fortissimo or something like
should have
that.
invited people to wear costumes today.
I thought the restaurant provided that. Well, thank you for pointing it out. Very clever.
You did, so did Walter.
And next week we'll have pumpkin pie. Okay, let's get on to justice matters and injustice matters. We've got with us Murray Newman, who was basically unknown to me. I was looking up a former speaker on the internet and discovered that this man had been blogged about by our speaker today because this fellow had died a couple years ago, and Jim Lindeman. And he worked for the county, he wrote an op-ed, which I have saved, and I came across recently about how to fix the problem with corruption in the contract process. The feds have a procedure, and Jim Lindeman was recommending that Texas should adopt it too, and I've always kept that in mind. So I discovered this man has a blog, and he comments on life in the criminal court system, and I thought I should invite him in, and he can talk to us about what he does and what's actually going on down there. And just recently, his name appeared in the paper dealing with some of the debates taking place regarding the race for district attorney. So perhaps you'll talk about that as well. I give you Murray Newman.
All right, Murray Newman.
Thank you all very much for inviting me. I want to tell you a little bit about myself, not because I think it's particularly interesting, but because it's some things that I'm going to address backwards, talking a little bit about my family, so I thought I'd tell you a little bit about them. I'm married to a wonderful lady named Emily Smith. We have a son together named Smith Newman, who just turned 1 year old on Wednesday, and I have a son from a previous marriage named Luke. I grew up in Bryan College Station. My father runs a small printing company there, and he bought it from his father, and it's been in business for about 65 years now. It's very interesting being the son of Lewis Newman because my dad is one of the coolest people that I know. He is a Marine Corps officer. He served 3 tours of duty in Vietnam. He's 10 times better looking than I am, which is not saying much, I understand. But he looks kind of like Kevin Costner, and he is my hero. And he's someone who has always provided me with some sage advice as I've gone through life. And you'll hear me talking about my dad a couple of times as I talk to you all today. I am extremely flattered to be asked to speak to you all. I don't get asked to speak very often, and that reminds me of a story about my dad. When I worked for my dad at the printing company from the time I was 16 years old to the time I left for the big city of Houston to go to law school. I'm an Aggie, and I went a whole mile away from my hometown and my house to go to college. But when I got my first job after my first year of law school, it was working as a clerk for Hinton, Sussman, Bailey, and Davidson, a very prominent criminal defense firm here in Houston. And I called my dad, and I was very excited. I said, "Dad, I've got this law clerk job." And he said, "Well, that's great. How much are they paying you?" And I said, "Well, Dad, they're going to pay me $12 an hour." And he said, "How much was I paying you?" And I said, $8 an hour. And he said, "I didn't think you were even worth that." So I think of that to keep myself humble whenever I'm invited to speak. The criminal justice system is something that I've always been fascinated with. Growing up in Bryan College Station as a kid, I actually lived across the street from our elected district attorney. His name was Travis Bryan. The town was named after his family. And I thought that what he did was amazing. Anything that he was in the newspaper all the time, he was dealing with murder mysteries. It was an exciting thing that he did. And his son and I were best friends growing up, and I just would go over there because I wanted to hear Travis Bryan, who's now Judge Travis Bryan's stories about what he did. And I realized from a very early age that there is nothing that just keeps you fascinated and to some degree even entertained like criminal law. Even those that are not involved with it, they're interested in it. You read your crime novels, you read your true crime stories, you watch Law and Order on TV. The thing is, it's just something that's an interesting topic, and it sucked me in at a very early age, and I knew that I wanted to be a lawyer, not because of the law, but because of the criminal law, and that's what I always wanted to do. And so that was the track that I took. I ended up, after graduating from University of Houston Law School in 1999, immediately starting at the Harris County District Attorney's Office under Johnny Holmes. Very proud to say that I was hired by Johnny Holmes, and when he retired, I told him it's kind of like getting to say you were one of Wyatt Earp's deputies. Because Mr. Holmes was one of the last great Texas lawmen, in my opinion, and they don't make them like that anymore. I served there from the district attorney's office from 1999 to 2008, and then I went out on my own, and I've been doing criminal law as a defense attorney ever since. And during the time that I've been either a prosecutor or defense attorney, the criminal justice system, not just in Harris County, but across the state and across the country, has changed more than I think it has in the decades that led up to this past 10 or 15 years. You are actually starting to see a shift from the hardcore law and order, no excuses type of mentality when it comes to criminal justice to something that is adapting. And we're taking into account more issues like marijuana and maybe not bringing out all guns blazing in the prosecution of marijuana. You're taking into account different things such as mental health. That's to me been the biggest change since the time I started at the district attorney's office in 1999 to now, that you're actually seeing the criminal justice system address people that have significant mental health issues and want to do something about helping more than just locking away. And to me, that's a very positive change. When it comes to marijuana, though, I do want to point out that at least 2 of the states that did legalize it had Super Bowl contenders this last year. So that's, to me, that's one of the best arguments. Both Washington and Colorado ended up in the Super Bowl. But you do see, even with Republican candidates who are typically known more for being a little more right-wing and the harder core of on the criminal justice side, even they are adapting softer stances on marijuana cases. I believe Devin Anderson, who is right now the interim DA, she is running in her own right now against Democratic candidate Kim Ogg. Even she has been talking about making plans to do diversion on marijuana cases, on personal use marijuana cases. And in my opinion, that just makes sense. No one should ever have their criminal history record forever tainted because of personal use amount of marijuana. So going back, though, to criminal justice system, and if anybody has any questions, please jump in at any time. I'm just kind of flying off the cuff here. But I will go back to talking about that it is such an interesting topic to be involved with because of the human drama that goes behind it. One of the things that I do as kind of a side job to my criminal defense is I also work as a legal consultant on the TNT show, Cold Justice. Kelly Siegler, who ran for DA in 2008, has her own television show. Is there anybody who's seen it? Basically, they go across the country working on cold murder cases, and Yolanda McCleary is with her on that, and she's actually the lady that they base the Las Vegas CSI shows on. And people tune into these because there's such an emotional pull to these type of cases, and that's what I enjoy about it, because it is a thing where it is a faction of life where you can actually find yourself very involved in someone else's life and making a difference. I tried during my time as a prosecutor probably somewhere between 15 to 20 murder cases. As a defense attorney, I think I've defended about 5. And the attitudes are kind of shifting towards more understanding towards the defense bar than they did back when I started in 1999. When I left the district attorney's office at the end of 2008, I wanted to talk about perhaps doing some business in Brazos County, where my dad's, like I said, is a printer. And my dad said, do you have to advertise that you're doing this? I'm not real sure that I want everybody to know that my son is a criminal defense attorney. because there used to be kind of a stigma about it, that criminal defense attorneys were the guys that got the guilty guy free of those charges that he was so justly accused of. But that's not always the case. And you've seen in the past 3 or 4 years with the case of Anthony Graves and Michael Morton, an idea that, you know, we should take defense claims and actually look at them very seriously. If a person's guilty and convicted beyond a reasonable doubt, by all means, punish them appropriately. But just because a defense attorney's lips are moving doesn't necessarily mean that he's lying. And how many of you all are familiar with the Anthony Graves and Michael Morton cases? Anthony Graves was sentenced to death for, I believe, a 1992 capital murder where 6 people were killed. Kelly Siegler ultimately got appointed as a special prosecutor on the retrial and found that evidence had been hidden from the defense that actually exonerated Anthony Graves. He wasn't just, they couldn't prove it. This was a man who had spent about 19 years on death row for a crime he had absolutely nothing to do with. And that is a terrifying prospect, because if you've got a guy who's sitting at home and can suddenly find himself on death row, how can you say it couldn't happen to any of us? He was doing nothing wrong, and that's where he ended up. And then you had Michael Morton, which was a case out of I believe it was Georgetown area, where he was accused of killing his wife. And he was found guilty, sentenced to life in prison, and after 25 years, he was exonerated. And the thing that was most troubling in both of these cases was you had instances where prosecutors were holding evidence that tended to show that the person accused was innocent, and they sat on it, and they didn't share it. And there's a legal battle going on right now on Anthony Graves's prosecutor, a man named Charles Sebesta, where he may lose his license. The prosecutor on Michael Morton, that, as troubling as it is that a person would be sent to death row, there were so many tie-ins to the Morton case because the person who did actually get proven to have killed Michael Morton's wife killed another lady in the time while Michael Morton was sitting in prison. They didn't pay attention to the right guy. Michael Morton, all he had left after his wife was his son. And his son was raised to believe that his dad had killed his mother. He dropped his father's name. He wanted nothing to do with that, and it was just an absolute insult to injury. There was a fantastic documentary on the Michael Morton case where they interviewed him, and they said, "You're up for parole, but as part of your parole, you have to admit that you did it." And he said, "I've lost my wife. I've lost my son. The only thing that I've got left is the fact that I know I didn't do this." And he held on to that belief, and he was exonerated. And because of the Michael Morton case, the law changed. How many of y'all keep up with this at all? I know that you do. But effective January 1 of this year, the Michael Morton Act took place. And it came in, and it basically said prosecutors no longer get to pick and choose what evidence they will turn over to a defense attorney. They now pretty much have to turn over everything. And it used to be that prosecutors were only required to turn over that which they found to be exculpatory or something that might negate the guilt of your client. The problem was you had the fox guarding the hen house on that. You had prosecutors saying, "Well, I don't think that that's relevant, so I'm not going to turn it over." And the classic example I always used was if you had a guy who was murdered in front of 20 people, and 19 of them said, "That's the shooter right there," and pointed at your client, but the 20th person said the Easter Bunny did it, a prosecutor would say, "Well, that's ridiculous. I don't need to turn that over." However, they don't get to make that call, because if you've got someone saying that it was an alternate suspect, even if that alternate suspect was ridiculous, they still had to notify the defense. And what you had in both the deal with Sebesta and Anthony Graves and Judge Ken Anderson on Michael Morton was that they had made judgment calls. They were so convinced that they had the right guy prosecuted that any evidence to the contrary must not be credible. And because of that, you had 2 innocent men spend a lot of their lives in prison. That's changing now, and people are now more open to the idea, and you can see it when you pick a jury. When the juries come in, you don't have the people that are there with the attitude of, "Let's give this guy a fair trial than a first-class hanging." you're seeing more and more jurors that are open-minded, that are taking the standard of beyond a reasonable doubt seriously when they swear their oath as jurors. And to me, that's a positive thing, because one of the things that I realize more and more as a defense attorney is that if you have to spend 2 minutes with your freedom taken away unrighteously, that's 2 minutes way too long, and it's something that we take for granted. I certainly took for granted when I was a prosecutor, but when you see the hardship that it occurs from just a weak reset on a case while they cross some T's and dot some I's or call some witnesses, if a person has lost their freedom, they lose everything, even if it's for a short amount of time. So I tell you that. I don't know how much it has to do with realty, but I do hope that it's something that you'll keep in mind when you serve on juries, that always hold the prosecution to that standard of proof beyond a reasonable doubt, because it's important and it does matter. And that's pretty much all I have. If you all have any questions, I'll be happy to answer them. Yes, sir.
About not long after you came into the prosecutor's office, I had some brush in with them, and became very frustrated for several years as to the fact that prosecutors seem so accommodating to people who are fellow public servants, or especially prosecutors, policemen, and not only policemen, which is what really bugged me, but people who had been driven out of the police department, you know, without being prosecuted or whatever, and slipped out, sort of. And anyway, after a while, I began to understand or think of my own business and think about how when people come to ask me, I'm a piano teacher, people say, well, how did this other teacher do with these kids? I don't start saying a lot of bad things about some other piano teacher. I don't know what they did at the time and so on, and I don't think that's fair. So in a sense, I'm being defensive about my field as well. So I was starting to think, well, you know, it seems like grand juries should be spending more time, but maybe somebody else too. I mean, didn't we used to, in the legal field, I mean, people could individually go and prosecute somebody, couldn't they? I mean, how did this get taken over that only the state does that? And so therefore, if a prosecutor is doing something wrong, who is supposed to prosecute them?
Right, and that's just going to be part of the problem with just big government. It's kind of like along the same ideals of what Winston Churchill said about democracy being the worst form of government except for all others. The reality is, can an individual prosecute someone? They can file a complaint with the grand jury and ask that the grand jury investigate it. But as far as them standing before a jury representing the state of Texas, there has to be, you and I can't just walk up and do that. I mean, unless there's been some sort of appointment as a special prosecutor or as an attorney pro tem. If you look at every criminal case, they're lawsuits, except one party is always the state of Texas. And it's going to be the state of Texas versus the person accused. So if you're going to be the person making that accusation, at some point you have to affiliate yourself with the state of Texas to be the prosecutor. Does that make sense? But
well, that's what I'm wondering, whether that needs to be in another issue, which I think is prevalent around here and other places, is the idea of the national government. We don't like the idea of the national government doing things, and yet, on the other hand, when we have, you know, basically prosecutors or some, you know, city council people and whatever misbehaving, basically it seems like we go to the national government and ask the Attorney General of the United States, you know, why can't we have some way here of a better, I mean, I think that the prosecutors does a great job of prosecuting people who smoke marijuana, but they don't do nearly so well at prosecuting people who violate their oath of office of public servants.
And I understand what you're saying, and that it can absolutely be a problem. But my belief is the biggest solution to that, ironically, has become the media. When you bring attention to these types of cases, that will oftentimes spur your elected officials into action if you don't believe that they are doing what they're supposed to be doing. You actually also have the safety valve of the Texas Attorney General's office or the Texas Rangers. If you think that there's an instance of some sort of official oppression and you don't think it's being investigated properly, you can always make You can always file a police report. You can file one sitting where you are right now. And if that's not being handled appropriately or given the proper attention that you feel that it deserves, there's always somewhere up the chain that you can go, whether it be the Attorney General's office in the Texas Rangers, or whether it be Wayne Dolcefino at Channel 13. Well, I guess he's not there anymore, or an investigative reporter. It's amazing how much in the past 20 years that the elected official is so much more afraid of a camera and an investigative journalist than they are of the law sometimes. So, yes, sir.
I'm concerned about the interrogation of suspects by the district attorney's office. They're allowed to lie to them and say, oh, we have a witness, this is all you leave the murder scene. That can be a total lie. And they intimidate them and scare them, and some of them confess the crimes they did not commit. All of that could be stopped if they would videotape all these interrogations. Is that in the works now?
Well, for a person who's accused of a crime, for their statement to be admissible against them in a court of law, if they give what is called a custodial statement, if they're in custody, they're not free to leave, they're brought in, if they're going to use that in trial against them, one of two things has to happen. Number one, it has to be video or audio taped where the Miranda warnings are given to them very clearly on that tape. And at the end of the Miranda warnings, they say, knowing those rights, do you understand them and agree to waive them and proceed? If that part is cut off of that video or audio tape, and it's a custodial interrogation, the jury's never going to see that. If it's a written one, which is before the media age was much more prevalent, you had these handwritten statements that you had to have the warnings printed on the page, initialed and signed, and before that could be admitted. You don't see many written confessions anymore. Almost everything is caught on digitally, on video, or on audio. Now, ironically, that's problematic for the prosecutors, because not because they're worried about rights being violated, but because some of these things last 4 hours before they get to the point, and they get really, really boring, especially if you're a juror and you want to get back home to your family or get back to your job, and you're having to watch a tape of 4 hours of idle chatter before the last 15 minutes gets to the point of the crime. But you are right, they can absolutely lie to them. They can say, hey, you know what? We found your fingerprint at the scene on the murder weapon. We found your DNA near the body. They can lie.
Why is that allowed? I mean,
it just is. It's something that's been contested. I will tell you this: jurors don't like it. They don't like it one bit because it affects. If you have a police officer who's testifying and he's about to play a confession, and the defense attorney can say, didn't you lie to him? You told him his fingerprints were on there, his DNA was there. All of that was a lie, wasn't it? And all of a sudden, the police officer is the one looking like a bad guy. It used to be much more prevalent in the 60s, 70s, and 80s, but now you see more scrutiny towards officers, and they just don't like it. Jurors don't like it. You still see it happen every once in a while, but it's become less and less just because public perception is that it's unfair. The idea of a statement that's given in the course of an investigation is that it must be voluntary, that you didn't feel threatened, you didn't feel like you couldn't leave, that your departure from the police station was contingent upon you telling them what they wanted to hear. And so I guess lying to them, they just kind of assume, well, no one's going to admit to something they didn't do just because someone lied to them. I disagree. I'm with you, but it certainly makes the officer look bad when he blatantly lies about that. Yes, ma'am.
Could you tell me the channel that some of those murders are displayed on TV? What channels? I think you find them on, do you know?
All of them, pretty much.
And what is it called again now?
The show that Kelly Siegler and Yolanda McCleary does is called Cold Justice. It's on TNT. We're actually still in the middle of filming right now for season 3, and they will resume in January right after the NBA playoffs, or around that time. Yes.
Hi. How you doing?
How are you, Walter? It's been a long time.
It's been a long time. I came a
I'm glad to see you're still alive.
It's been. By the way, the U.S. Supreme Court has condoned the lying part of it. That's been litigated
right.
many years ago. And I just, by the way, Kelly Siegler, she really, they're doing a good job on that TNT. She was definitely my favorite, the race against Judge Likas back there. And the whole district attorney's office, in my opinion, would have been better. But I got to get on you for what I've read about you in the paper recently.
Okay. You won't be the first today.
No. But I mean, you're for Devin Anderson.
I am.
And you have made a charge. Didn't you get on the giant bandwagon accusing Kim Ogg of unethical violation on that client?
Yes, I did.
Can you tell us a little bit about that and
Sure.
justify what you're saying about one little incident now? Okay. Why don't you tell us that?
Yes, sir. When any person walks into an attorney's office, even if they don't end up hiring them, the second they walk into that door, pick up that phone and begin talking to them, attorney-client privilege has begun. Even if you don't hire them, your conversation in anticipation that you might hire them becomes privileged, and it becomes confidential. That is between you and your attorney. And that law has always, that's one of the canons of our profession, because you want to foster the idea that a client knows that he can share everything with his attorney so his attorney can adequately advance the cause that he is hired to do. You would agree with that, correct?
Pretty much.
Okay. So what you had in this case with Kim Ogg, and this is why I'm upset with her about what she's done, was she had been hired to represent, she and her father, Jack Ogg, had been hired to represent a young lady who is having trouble with her husband. And this lady's name was Janet McAfee, and she was having issues with her husband, and even apparently he had some mental health issues to the degree that she was trying to get guardianship of him, legal guardianship. And that's why she had hired the Ogg law firm to help her out with that. Ultimately, the issues became too much, and she decided to seek a divorce from him. At some point, she split sheets with the Ogg law firm, whether they got rid of her as a client or whether she fired them as her attorneys. By the time that she is subsequently murdered by her husband, she and the Oggs are no longer together as a attorney-client. But everything that she said to them is still attorney-client privilege. Everything that she said is protected because it extends even past your death. It becomes an issue for your estate over whether or not you want to waive your attorney-client privilege. In this case, unfortunately, her husband murdered her on May 10th of 2010, and he was charged with her murder, and it landed in the 339th District Court. For some reason, the Ogg law firm thought that they were going to be the attorneys on a wrongful death action on her behalf against her husband. And that did not occur because ultimately her family chose a high school classmate of Janet McAfee's named Kelly Siegler. They chose Kelly Siegler and an attorney named Dean Bloom-Rosen to represent them in a wrongful death action. So, and that's completely separate. In the meantime, you have Ken McAfee charged with murder, and he is going to go to trial on murder. His attorney is Gerald Fry. Gerald Fry is working for the killer of Janet McAfee. Is everybody on board so far? They have very different interests. He wants to do the best he can for his client. So he asks for the Ogg firm's file on Janet McAfee. Did she ever say anything bad about him? Was there anything that might mitigate, might show that maybe she needed to be shot, or maybe she wasn't quite the angel the prosecution is making her out to be? Now, if I'm the Oggs and I get a call from the person's attorney who killed my client, I can't say that on public TV what my response would be. I would tell them to get out of my office. That's obscene. I would never turn over my client's file to the person who killed her for anything. And if a judge ordered me to, I would tell the judge, you know what, the rules of that govern attorney-client privilege say I don't have to, and if you're ordering me to turn it over, judge, you're wrong, and I'll go to jail until somebody agrees with me before I turn over my file to that man and his attorney. That is what the Ogg firm should have done. But what you had in the paperwork that Gerald Fry formed was he filed an order asking, a motion to ask the judge to order the Aug firm to turn over their file on Janet McAfee to the defense. And this is where it was bad. This is what I took issue with, is that you have to write a certificate of service. And in that, he said, I have already spoken to Kim Aug about this, and she has no opposition to this order. She is fine with turning over her entire client file on this poor deceased woman to the man's attorney, on the man who killed her. And to me, that violates the rules of attorney-client. This is what was attested to. He signed a certificate of conference, and he turned it in as a sworn statement to the court. And she did turn it over. She did, once the order came down. Once the order came down, she did turn it over. And that's not an unusual thing. Say, look, I can't tell you, like, let's say, look, I can't turn over say I'm a principal at a school, and you want a student's records, and I say, well, I can't give that to you. I'd love to give it to you because that's the worst kid in my class. But if you can get a court order, I'll be happy to give it to you. And that is what it appears Kim Aug did. I can't give it to you. You know I can't unless you get a court order. We have, you know, Pat McCann, highly respected criminal defense attorney. He had an instance where he represented a guy who was charged with capital murder. And he had a huge file because Pat's a really good lawyer. And they ultimately, the guy got prosecuted. I believe he got sentenced to death. And his appellate attorney said, I want that guy's file. I want your former client's file. And Pat said, I just need him to sign a waiver saying that's okay for me to give you the file. If the client blesses off on it, it's fine. Well, this client wouldn't do it. He didn't like his new attorney, or for whatever reason, he did not want Pat McCann to turn over his file to his own appellate attorney. And Pat refused to give it to him. And Pat nearly went to jail for that because the judge ordered him, said, I order you to give your file to the defense, to the appellate attorney. Pat said no. And it ultimately got litigated, I believe, in the Court of Criminal Appeals. And they ultimately told Pat that he was right, that a judge can't order you to turn that over.
Okay,
Yes, ma'am.
so the judge can't order you to turn it over. And if you don't turn it over, then you might go to jail.
You might. Yes,
Okay.
ma'am.
Then let's take the other scenario the other way. Then the law says that it's confidential, and so of course the attorney then does not go to jail, or somebody agrees he doesn't. But the judge wrongfully issued an order. What happens to the judge?
In reality, probably nothing.
Right.
You can get what's called a writ of mandamus, which is an order from a higher court telling the lower court to act right. But as far as them...
Okay, so now there's an area for you guys to work on.
Yes, ma'am. Well, we're always working on it. Trust me, it's a daily struggle.
I just
I can
need to
imagine.
pursue this a little bit. This is a lot of minutia here in the weeds, and but I'm not arguing her point. I think she's got some counterpoints to that, but I haven't talked to Kim Aug about it. But I want to ask you, is this the only thing you've got against Kim Aug?
It's not. There have been some other issues that I've seen where you know as well as I do that there are some issues that make better political issues than they make legal issues. And I think that I've seen her do some things which is capitalizing on a non-criminal lawyer's lack of knowledge about the system and tried to make it a bigger issue than it actually was. For instance, she made a big deal out of the Houston Police Department investigation into a homicide investigator, and she said it wasn't handled properly when they asked the Montgomery County District Attorney's Office to be the special prosecutor on it. And that's ridiculous. That Harris County has an agreement with the contiguous counties around it, Brazoria, Galveston, Fort Bend, Montgomery, that if they have a conflict of interest on investigating a case, that one of the other counties does it. Saves money. They don't have to pay money to an individual such as myself to come in as a special prosecutor. Kim Aug tried to make a big deal out of it, acting like it was a highly irregular occurrence. It was trying to whitewash what happened. And when you see someone, especially who's aspiring to be your elected district attorney, basically trying to whip the media into a frenzy that she knows doesn't have legal teeth to it, that concerns me, because that's trial by popular opinion and not the law.
the way it is. Do you agree with Devin Anderson's recent commercial where she says that Kim Ogg is dangerous, will be dangerous? Have you heard that one?
Well,
because of her business about the marijuana and crack cocaine.
I don't know that I've actually seen the commercial. I am aware of it. That's why I hate politics in the criminal justice system at all. I think
put it down that you don't agree with Devin Anderson doing that?
You cannot put words in my mouth. I can tell you this. I don't think that partisan politics should play anything to do with criminal justice. Unfortunately, that's just the way it is and probably will be for a long time. And as long as it is, you're going to have people making these huge claims in ads. So do I think dangerous is an overstatement? Yes, and you can attribute that to me. Yes, sir.
Something popped up, I think it was in the Chronicle. This gal had bath salts on her, and she was tried, convicted, and everything, but it was 2 days before it was illegal.
Then that should not have happened.
Yeah, it appears to be everybody dragging their feet on it, and it's just popped up.
The criminal justice system is too big to be mistake-free. It happens all the time. That's why there's an appellate court. That's why there's appellate courts for the appellate courts. And the Supreme Court, that's the appellate court for the appellate court for the appellate court. And that should not be happening. That should absolutely not be happening. But the problem that you're going to have in any major city is volume. You want to truly solve the problems in crime and overcrowding, we need to have at least 3 times as many courts as we do now, 3 times as many prosecutors, because you have people that will await their day in court for 5 years. And sometimes they'll spend that time waiting in jail. And there's just not enough structure to deal with the level of crime that is out there in any big city. Yes, sir.
A couple years back, we had somebody come here from the prosecutor's department. I guess you weren't there by that time. But anyway, it seemed to me, I may have misunderstood some of this, but it seemed to me like that there was a bunch of overgrown teenage black guys on the tops of Toyotas or something in some apartment complex. The apartment owner called the cops, and the cops weren't interested whether they were smoking grass or not. And so the district attorney got involved and started going after them through injunctions, and as a way of circumventing having to prove innocence beyond a reasonable doubt, or even meeting the needs of the police department over what was a priority in terms of
and Kim Ogg was the head of that program. Kim Ogg was the head of that program with the injunctions. Back then under Pat Lycos with Haverstock Hills. Haverstock Hills is a very high crime apartment complex, and that basically became the mantra, is like if something happened in Haverstock, they were going to pay so much more attention. The recommendations, you could get busted for a joint walking down Main Street and they could offer you 5 days in jail, but if they busted you at Haverstock, now it's 45 days because you came from Haverstock. Now to me, that seems like you're not being equally protected. It seems like you're getting a little punished a little bit more because of where you live. And they also did the injunctions.
Has that been scaled back then, or has that been built upon in that time?
In all honesty, I don't know. I don't know the answer to that question because I've been gone from 2008. Judge Lycos made a big deal out of it. She touted it a lot during her administration, but to tell you the truth, I deal with mostly felonies, and a lot of those cases were in misdemeanors. I have not seen what they just called the Haverstock cases, where they are singled out for different treatment. I have not seen that in a long time. Whether or not the injunctions are still in place, I can look into that for you and try to get back to you, but I don't know the answer to that.
Before you leave, why don't you tell us about your blog and how we access it, and the others that are blogging around here, your competitors.
I don't.
May or may not like too much.
Well, no, I started blogging in the early part of 2008 when Chuck Rosenthal had his scandal that basically pretty much was the starting point of what ended my career at the DA's office, because a lot of us got fired by Pat Lycos, mostly because we supported Kelly Siegler. But I started the blog because when Chuck Rosenthal got in trouble for these racist and sexist emails, almost everybody in the media was just hammering on what horrible human being you must be to be a prosecutor. And that didn't sit well with me, so I began a blog. And February of 2008. And I was anonymous at first because I was still a prosecutor and I didn't want it to be taken as I was speaking on behalf of the district attorney's office. It ended up getting politically active. Ultimately, when Pat Lykos gave me my walking papers, I did come out of the closet, so to speak, and say, this is me. It was like the worst kept secret in the courthouse. But I don't look at my fellow bloggers as competitors. We kind of feed off of each other with different topics. Yes, sir.
I'd like to remind everyone who gets our notice that in this week's notice, his blog specs are on there. It's in the email. If you did not get the notice and would like to, give me your email address.
And I'll be happy to tell you, it's really wordy. It's so long. I didn't go for brevity in the blog title. It's called Life at the Harris County Criminal Justice Center. It's like harriscountycriminaljustice.blogspot.com. Anytime someone asks me for it, I was like, just let me write it down for you, and I'll be happy to do that for you today for anybody. Yes, sir.
A couple years ago or whatever, somebody was in the prosecutor's department. I believe it had to do with the that roving DWI thing or whatever, and went before I gathered a grand jury, if I understood it right, and pled the Fifth Amendment for work that she had done for the state, and that seemed to me very odd. I mean, how can you be confessing to having done criminal work when you were a prosecutor and then still expect to have your job, especially? Can you explain that one to me?
Well, I can try. What you had on that particular issue was that you had these roving DWI vans like you had. They were basically mobile units that had an intoxilizer in them so that if they arrested someone, they could immediately get a breath sample from them right then and there on the spot, not have to worry about taking them downtown and the time frames where you could still get a valid sample. You had at least two members of HPD saying, well, look, these are really technical, finely tuned instruments that have alcohol basins in them, and they have to be kept properly. Well, if you're leaving them in a hot car in the middle of July in Houston, you're going to mess up the validity of those instruments. And they made notice of this, and they called out and said, look, they called them the BAT vans, the breath alcohol testing vans. And they're like, these BAT vans are not reliable. And these were their chemists, their experts at the HPD crime lab. Well, when they made enough noise about that, they got fired from HPD. And they went to, I believe it was one of the junior colleges that basically they operated in their same capacity, except they weren't doing it for the Houston Police Department, they were doing it for the county. Now, the allegation that you're talking about comes out of the Lykos administration was alleged to have found out that these chemists had gotten new jobs and gotten them fired from them. They had contacted them and said, fire these people, we don't want them testifying, and it was alleged that they were retaliating, that they were using, the grand jury was impaneled to see if there was official oppression. Was a government agency basically trying to get individual citizens fired because they were whistleblowers? And it became a madhouse. There was a lot of stuff going on. There were special prosecutors. One of the people involved was a young lady named Rachel Palmer. And she was, and I believe her husband actually attends these events quite regularly. She was a higher up in the misdemeanor division that tries most of the DWI cases. Most people that get DWIs are first or second offenders, and those are treated as misdemeanors. So she had a supervisory position as what we called the deputy dog of misdemeanor. And she was called upon to testify as to what was said and when about all of these issues regarding the BAT vans. And at some point, when she went in to talk about it, she pled the Fifth and said, I'm not going to testify. Now, playing devil's advocate, which I often do as a defense attorney, the Fifth Amendment is not supposed to be used against you. That's the whole purpose of it. If you say the Fifth Amendment, it's not supposed to be some sort of trigger that you believe, oh, they must be hiding something. It's literally supposed to be your neutral card. I have chosen not to speak, and that shall not be held against me.
Well, I have to object to that. Well, I consider you waived that when you take the oath of office to do the best that you can to do your job. How can you do the best that you can to do your job, and you can't explain what you're doing with it, and have to say that, you know, I can't talk about it because I might have broken the law? That doesn't make any sense.
And philosophically, I agree with you. Legally, I can't, because it doesn't matter what job that you have, you never waive your constitutional rights, because they travel with you. Now, if they could prove that without your statement, if they can prove your wrongdoing without your statement, well, you can actually be punished more severely because of your role as a public servant. But that doesn't mean that you lost your Fifth Amendment protection.
No, well, I'm not saying that losing your job as a prosecutor is not the same as losing your job as a, you know, she could take the Fifth Amendment and submit her resignation. Now she's put under trial perhaps for having committed a crime. She's got her Fifth Amendment protection. She didn't testify against herself when she went to the grand jury, but she's not a prosecutor anymore. This is what I don't understand, how it is that somebody, and I feel in some sense like you're evading my question.
I'm not trying to.
What is the idea? Under what circumstances can a prosecutor break the law and expect to keep their job?
Well, see, you're making a leap of faith and logic here. You're assuming by invoking her Fifth Amendment rights that she did break the law. And the Fifth Amendment...
She did break the law because she's not doing the best that she can to serve the public. She's not answering to me and the rest of us as to what she was doing. And she took an oath of office that said that she would. She broke that law.
But see, and trust me, when I tell you, right, this particular prosecutor that you speak of, she and I are not friends by any stretch of the imagination. Neither is her husband and I. He actually has a blog devoted to bashing me because of this very issue. I philosophically am very much on your side. However, the law states that the Fifth Amendment is a protection, and you can't read into it what a person invokes it for. When I'm picking a jury and I'm asking, is there anybody here that's going to hold it against me if my client testifies, the way I will couch it and say, look, we're all human. Law says you can't hold it against my client if he doesn't testify. And how many of you, though, if you're back there and you're deliberating and you're in that jury room and you're like, ooh, it's close. I'm not quite at a reasonable doubt. I don't quite believe he did it beyond a reasonable doubt, but man, it's close. I think he probably did it. But you know what? He didn't testify, and if he was innocent, he would have. So you know what? I'm going to go ahead and convict. You can't do that. Even though it's human instinct, even though it's human nature, even though it's maybe philosophically correct, that if you didn't do something you're accused of, you'd scream it from the highest rooftops that you didn't do it, legally, you're protected. And it can't be used even slightly against you. Trust me, philosophically, I'm with you, man. Let's talk.
How is she doing the best that she can to do her job when she can't explain what she was doing?
Hey, you're a government employee. I don't think you're legally required to do the best you can. I mean, I'm kidding. Yes, ma'am.
It seems like I've heard, you know, court cases where the defendant would say something like, I plead the Fifth to prevent self-incrimination, something along that line. Why would they say that then?
They don't ever say it, and it's actually a good point, but it's an interesting point. You probably don't know this, but if a person invokes their Fifth Amendment right, the jury is never told that. If a person is being interviewed like by the police, like we talked about in their recorded statement, and suddenly they say, I want an attorney, or I want to invoke my Fifth Amendment right, that part of the tape will be cut out, because they don't want to create an impression that they're doing so because they're guilty. And if a person is taking the Fifth Amendment right during trial, they never say those words in front of a jury. Their defense attorney just never puts them on the stand.
They don't say something about self-incrimination?
No, because the prosecution is not allowed to call a defendant to the stand. They can't say, we're going to call Charles Manson next. They do that, the trial's over, it's a mistrial, it's prosecutorial misconduct. Trial's over, and they are barred from retrying it. The only person who can call a defendant to the stand is their own attorney.
I sure wouldn't agree that it's they're barred from mistrial.
Well, that's arguable. I'd make that argument. Yes, sir.
Yeah. It's upsetting to me that someone actually would try and prosecute somebody for a capital crime that would send that person to the death chamber, and they withheld exculpatory evidence. Why can't the prosecutor then, when that's discovered, be then accused of attempted murder?
And there are a lot of people that agree and think it can be. It just hasn't been done. You've got to find a prosecutor willing to file those charges. I believe that you can be under the law. What do you think about that? I think you could try a prosecutor who willfully disregards evidence that's trying to get someone the death penalty can be tried for attempted murder.
Well, who's going to prosecute?
Well, that's the question. But I think on the books you can.
Maybe you will.
Maybe so, but I got to get sworn back in by the state of Texas. I'm going to take him, and then I'll take you. Yes, sir.
Okay, on this pleading of the fifth, we've all seen news clips, to say nothing of movies, where there's a congressional hearing.
Oh.
And the mob boss will come out with that comment. I refuse to answer that question on the basis it might incriminate me, blah, blah, blah. We've seen that a lot. Now,
Sure.
But that's different from a trial, right?
Well, it's apples and oranges, and I am by no stretch of the imagination a congressman. The bottom line on something like that is that you're going to get slaughtered in the court of public opinion when you do that. But the court of law, that just can't be evidence. And you can have all kinds of instructions to disregard, but the fact that someone did it cannot be held against them.
Well, I'm talking about a congressional hearing.
Yes, sir. I hope to avoid those.
Like the mafia hearings at RFK did.
Right.
We have heard that phrase.
What about this murderer who took the fifth after she had already testified?
Well, once again, she's getting slaughtered in the court of public opinion, but I don't know that legally that could be used against her. Did you have a question?
Yeah, one of the things you had mentioned earlier, one of the things I'm interested in about the criminal justice system is just kind of aggregate numbers. The other night I was talking to a current sitting longtime judge, Jay
Judge Carahan.
And he mentioned that his court handles 5,500 new cases, not including the old ones that we certainly back. I got to thinking that's over 80,000 cases a year. But you had mentioned something earlier about people who spend their time actually cooling their heels in jail while I'm assuming they're doing that because they can't make bail. Now,
right.
How many defendants, or what, would you give a rough guesstimate as to how many defendants end up just sitting there in prison because they can't get themselves out, or their family can't get them out, or
hundreds or thousands easily. Because if you're charged with like a murder, you may not have a bond at all.
It's a capital murder.
But the trick about the misdemeanors, though, is let's say that you are charged with possession of marijuana. You can't make bond. Or say you're an 18-year-old kid and you don't want your parents to know that you got arrested. Right. Well, a prosecutor may say, well, we'll give you time served right now, and you can go home. You don't even have to pay a fine. And so they say, well, that sounds great to me. Well, what they don't realize is that time served is a final conviction. And then they lose their driver's license.
Right,
and then it haunts them
once you've got a criminal record.
And you can never get it non-disclosed. You can't get it expunged. And you were so hot to trot to get out of jail, and no one explained that to you, the time served. And there's been a big movement to grant these people personal recognizance bonds on misdemeanor, nonviolent offenses, that they should be let out on their own PR bond so that they don't feel that pressure to plead to something just so they can get out of jail.
Not realizing the consequences.
Correct.
That you're not going to be able to get a job,
Right.
a loan, buy a house.
You could lose your college scholarship. You might not get a dorm. And that's where it just becomes ridiculous how punitive the low-level marijuana laws are, because
right.
It's
you
just.
You got a joint, and all of a sudden the rest of your life is wrapped.
Yes, sir.
There were some articles that the Chronicle ran criticizing some aspects of the grand jury system recently. I was wondering if you've ever indicted a ham sandwich, or if you could comment on your relationship with the grand juries.
Well, if you're talking about a ham sandwich being a simple case, I've indicted enough ham sandwiches to fill a deli, because some cases are just very, very simple. The reality goes back to the sheer number that we have of cases in our criminal court system, that if, let's say I'm a prosecutor and I'm presenting just a simple crack rock case, it may involve this. I sit down in front of the grand jury and I'll say, Officer Smith was driving patrol in Harris County, Texas on October 29th. At that time, he was at the intersection of Main and San Jacinto, actually Main and Texas. He saw the defendant cross the street where signal was not provided. He was jaywalking. He arrested him for said offense, jaywalking offense, a search incident to arrest, located a crack pipe in his front left pocket, field tested positive, and that's the end of the presentation. And the grand jury will make their entire basis of whether or not they true bill it or no bill it on a 30-second spiel. And so some of them are much more complicated and can involve calling witnesses, but I would venture to say the vast majority are like that. So did I prosecute cases like that? Yeah, absolutely, because if you gave 15 minutes to every crack pipe case, the grand jury would you'd need to have about 10 of them operating 24/7 with no holidays to keep up with the volume. I would walk in there, and prosecutors to this day will walk in there, and they'll have 60 cases that they need to present like in the next hour and a half. And that's just, I mean, it's just a sad fact of life, unfortunately.
I think a question for Jimmy, but I would ask a question first of all.
Yes, sir.
I think the most important thing you told us is that we need 3 times as many judges. Is that kind of statement in some kind of official document that some reformer types can refer to call for boosting the number of judges?
As far as did I do a study on it? No. I don't know. I mean, I can tell you on what I see. I mean, the average case that comes into a court is reset at 1-month intervals, on average. That basically you're going to come back every month on that case until it either pleads out or gets dismissed. And at some point, maybe somewhere about 6 months into it, I think we've got a time crunch.
2 minutes. Okay.
About 6 months into it, you're going to get your case set for trial. If you're lucky, you'll get your day in court within a year. Yes, sir.
In Harris County, when a defendant cannot afford to hire his own attorney, the judge appoints an attorney for him.
Yes, sir.
Gives that attorney a good payday, and they always
It's not that good.
work out a plea bargain. They threaten these guys with 20 years, and that you can take 5 or whatever. And so the attorney doesn't really care. He wants to get over it too. The judge wants to get rid of the case as fast as he can. So that's not very good justice at all, is it?
Well, I think like in any profession, your reputation is who you are. And there are certainly attorneys that develop the reputation of being what they call plead-out attorneys. And even the defendants in the holdover know it. They'll say, I don't want an appointed attorney. I want a free world lawyer. So there again, and I'll answer any questions. The show's about to wrap up, I think.
I just can't let it go that we need more judges. They are not working. They are not.
I'll let you take that up with the judges.
Well, I know, but you've done a really good job in my opinion.
Thank you.
I know. Very good.
Thank you very
Well,
much.
I want to make a good point. The judges apparently all play golf in the afternoon.
And the civil judges are working.
We don't have attorneys that are paid by the state now that will defend people.
There is, I do some appointments, I do some retained. It's about half and half. They also have a public defender's office. And the public defender's office was kind of controversial. It was coming around about the time that I was handed my walking papers, and I looked at them as a potential competitor, but they haven't been. They've actually been an outstanding resource. Their leadership under Alex Bunnan has been exemplary, in my opinion. They have some outstanding lawyers. They have investigators. Those guys try hard. And an indigent defendant who gets the public defender's office is very fortunate, in my opinion, because they are going to do an outstanding job. Yes, sir.
What decides whether you get the public defender's office or get an appointed judge by
I'm sorry, I don't.
An appointed lawyer by the
what they have, every court has what they call the wheel. There must have at some point been an actual wheel. But what they do is the court will, if they have an indigent defendant who needs representation, they'll hit a button. 10 names of attorneys who are on the docket or on the calendar that day that say, hey, I could take a new case if you wanted, will pop up. One of them may be the public defender's office. And the judge can choose from one of those 9 attorneys or the PD's office. And they can make that. There are some judges that refuse to use it. I think they're cutting off their nose to spite their face because they've got some fantastic defense attorneys there.
We're actually running out of time, so we have to say thank you very much.
Oh, thank you so much for inviting me. I'll stay around and answer any questions anybody wants.
And I guess you got some business cards with you?
Yes, sir.
We have some criminal types here who may need it.
Some of us don't know his name yet.
Murray Newman, and I brought my card.
Okay.
I loaded up.
Our speaker next Friday will be Pat Fant. He had an op-ed in the paper recently about why a local news station did not need to shut down. And so I invited him to talk to us about how that happened He's going to talk about the nature of modern internet radio. So next week we'll have a media presentation. See you in a week.
All right, now let's see what.
And thank you for this.
Everybody be sure to vote.
Well, that's right. Yeah, vote.